Great. Everybody sit down, please, and good afternoon. I'm Deborah Leff. I'm the Acting Senior Counselor of the Access to Justice Initiative here at the Department of Justice, and it is my pleasure to welcome you and thank you for joining us at our recognition of the 50th anniversary of the U.S. Supreme Court decision in Gideon versus Wainwright. The Access to Justice Initiative is just 3 years old. We were established by Attorney General Eric Holder to address the access to justice crisis in the criminal and civil justice system and help ensure that the justice system delivers outcomes that are fair and accessible to all, irrespective of wealth and status, because fair treatment and justice are the right of all people, no matter what their income. Today, just a few floors above us, people have been peering into a glass case, viewing a remarkable document, a document that proves that one man can make a difference. The National Archives, our next-door neighbor, has 12 billion documents that shed light on America's history. Many are stored electronically. Billions more are carefully filed in boxes. But only a relatively precious few are stored in the National Archives vault. We thank the Archivist of the United States, David Ferriero, who is here with us today, for sharing one of those precious documents with us. It is the petition sent to the United States Supreme Court in 1962 by a Florida inmate named Clarence Earl Gideon, a poor man who needed a lawyer and couldn't afford one. It begins, "To the Honorable Earl Warren, Chief Justice of the United States, comes now the petitioner, Clarence Earl Gideon, a citizen of the United States of America in proper person and appearing as his own counsel. When at the time of the petitioner's trial, he asked the lower court for the aid of counsel, the court refused this aid. Counsel must be assigned to the accused if he is unable to employ one and is incapable adequately of making his own defense. Your petitioner was compelled to make his own defense. He was incapable of adequately making his own defense." Clarence Earl Gideon took his case all the way to the U.S. Supreme Court, and he won for all Americans, for all of us, a ruling leading to a more just country. We are better now, but we have a long way to go, and we are honored to have with us today to talk about the legacy of Gideon and the path forward to fully realize its promise, a former vice president, a sitting U.S. Supreme Court justice, a former state Supreme Court Chief Justice, and 2 leading advocates who represent so much that Gideon fought for. And in this room today, we have so many public defenders and defense counsel for indigent persons. I would like all of you to stand and be recognized. Thank you. It is now my honor to introduce the Acting Associate Attorney General of the United States, Tony West. He is the 3rd highest ranking official in the Department of Justice. He oversees the Access to Justice Initiative, the Office of Justice Programs, which many of you know through its grants, the Civil Rights Division, and many other offices. And Tony is deeply committed to making sure that the right for which Mr. Gideon fought so hard becomes a reality for everyone. Tony?
Thank you. Thank you, Debbie, and thank you for your leadership of the Access to Justice Initiative and for really being the driving force behind this great celebration today. I'm privileged this afternoon to have 3 distinct honors. The first is to welcome and to thank all of you for joining us here today in the department's Great Hall. This hall symbolizes the fusion of 2 core principles that we hold dear here at the Justice Department: our respect for the majesty of the law, as represented by the figure on your right, and our conviction that law's proper role is in the service of justice, as portrayed by the figure on the left. And like the Gideon case itself, these statutes remind us that justice is as much a journey as it is a destination, as much a process as it is an outcome, and that we must give equal attention to both. Because in the half century since the High Court decided Gideon, we've made much progress along that journey, though we have many miles yet to go. My second honor is to share with you the thoughts of someone who couldn't join us this afternoon, but who nonetheless shares our sentiments. He writes, "I send greetings to all those attending the Department of Justice's celebration of the 50th anniversary of Gideon v. Wainwright. In 1961, an impoverished man, denied counsel, defended himself before the law and set the stage for what would lead to the landmark Supreme Court decision that moved our nation closer to realizing its founding principles of equality and justice for all. The unanimous 1963 decision in Gideon declared a fair trial cannot be granted without legal representation of the accused in criminal proceedings. And for 50 years, we've made remarkable progress in protecting the right to counsel for anyone charged with a crime, regardless of class or status. As we mark this important milestone, let us recommit to keeping the promise of Gideon alive for years to come. And on this special occasion, I wish all of you the best for an enjoyable event. Signed, President Barack Obama." And that brings me to the third honor, to introduce the Attorney General. Long before he led this department, where he spent most of his professional life, Eric Holder understood that as central to protecting the safety and security of the American people is to our mission here at the Justice Department, so too is safeguarding indigent defense and promoting access to justice. He understands that Gideon is both a legacy and an invitation. That's why early in his tenure he launched the Access to Justice initiative, because he knows that the scales of justice balance only when legal services are available, affordable, and accessible to everyone in the United States, regardless of wealth or status. That's why last September he made an historic appearance before the United Nations General Assembly, pledging that the United States would not shrink from its responsibility to improve access to justice for those who cannot afford representation. And that's why last week, before the Senate Judiciary Committee, when talking about the thousands of unaccompanied children who appear before immigration judges every single year by themselves without any lawyer, he said this: "It is inexcusable that young kids, 6, 7, 14-year-olds, have immigration decisions made on their behalf and they're not represented by counsel. That is," he said, "simply not who we are as a nation." With a boss like that, it is very cool to come to work every single day. I have to tell you, I am fired up. So, ladies and gentlemen, it is my honor to introduce to you the Attorney General of the United States, Eric Holder. Thank you. Thank you. Thank you. Thank you.
Well, thank you, Tony, for those kind words and for your leadership as the Associate Attorney General. It's a privilege to stand with you and with Deborah today and to be among so many good friends and distinguished guests here in the Great Hall. I'd like to extend a special welcome to former Vice President Mondale, to Justice Kagan, to Nina Totenberg, each of our panelists, and all of the federal and state leaders, policymakers, and jurists who are here with us this afternoon, particularly Representative John Conyers, Representative Chaka Fattah, Chief Justice Wallace Jefferson of the Texas Supreme Court, Chief Judge Jonathan Lippman of the New York Court of Appeals. I want to thank you all for taking part in this important ceremony. It is an honor to join you in commemorating the 50th anniversary of the Supreme Court's landmark decision in Gideon v. Wainwright. Now, today's observance marks a unique opportunity to remind professionals from across our nation's legal community about the sacred responsibility that every one of us shares. It provides a chance to call attention to the needs that we all must fulfill and the challenges that prosecutors, yes, prosecutors, public defenders, and policymakers throughout the country are called to address. And it's an important moment, not merely to reflect on our past, but to plan for the future and to recommit ourselves to the ideals laid out in Justice Hugo Black's historic opinion. 50 years ago this Monday, writing for a unanimous Supreme Court, Justice Black observed that, and I quote, "It seems to us to be an obvious truth that in our adversary system, any person hailed into court who is too poor to hire a lawyer cannot be assured of a fair trial unless counsel is provided to him," unquote. Now, this constituted a watershed moment and a critical step forward in our nation's enduring pursuit of equal justice for all, by holding that every defendant charged with a serious crime has the right to an attorney, even if she or he cannot afford one. The court recognized the significance of legal assistance in safeguarding due process. It furthered the aspirations of countless lawyers and activists who, throughout the history, have stood up and who have spoken out for the common humanity and basic rights of every citizen. And it paved the way for the expansion of the right to counsel in the years that followed. Yet the journey that led to this momentous decision began quite humbly, with an act as simple as it was profoundly optimistic. In 1961, a poor person, described as a drifter, named Clarence Earl Gideon, was arrested in Florida on charges of theft. He was forced to conduct his own defense after his request for a court-appointed attorney was denied. After a jury found him guilty, and even after his petition to the Florida Supreme Court was turned away, he remained undeterred. He drafted another petition in pencil on prison stationery, and he addressed it to the United States Supreme Court. In this truly extraordinary document, which is on display for this event here at the department, just a short distance from my office on the 5th floor, Clarence Earl Gideon appealed to the principles of fairness and equality that have always defined our justice system and that stood at the core of our identity as a nation. In 5 handwritten pages, he laid out a very straightforward argument that would, in the words of my predecessor, Attorney General Robert Kennedy, change the whole course of legal history. Now, as Gideon would go on to write in a reply brief, and I quote again, "It makes no difference how old I am, or what color I am, or what church I belong to, if any. The question is, did I not get a fair trial? The question is very simple. I requested the court to appoint me an attorney, and the court refused," unquote. In June of 1962, the Supreme Court granted Gideon's petition and selected prominent Washington lawyers to lead the team that represented him. And we're honored to have one of the members of that team here today, Abe Crash. And I'd like him to stand up so we can give him a round of applause. Meanwhile, the Florida Attorney General's office began reaching out to its 49 counterparts, asking for their support as it prepared to argue the other side of the case. But this strategy backfired when Minnesota's Attorney General, a young man named Walter Mondale, who was only a few years out of law school, strongly disagreed with Florida's position. Thanks largely to then Attorney General Mondale's advocacy, a total of 22 states signed on to an amicus brief in support of Clarence Earl Gideon. Only 2 submitted a brief supporting Florida. Then on March 18, 1963, when the Supreme Court unanimously held that Gideon's right to due process had been violated, the foundation of America's legal system was forever altered. Now, of course, the progress heralded by the court's opinion and the sweeping changes it demanded from coast to coast would not happen overnight, and they could never be handed down from the bench. In many ways, the decision would have to be put into action by the American people and their state and local leaders. In the decades since this remarkable case and Gideon's retrial, at which he was found not guilty, public defender systems have been established in some states and strengthened in others. Additional court actions have expanded the right to counsel in juvenile and certain misdemeanor cases. And our nation has made significant strides in fulfilling the promise of Gideon and ensuring quality representation for more of those who need it. Yet, despite half a century of progress, even today, in 2013, far too many Americans struggle to gain access to the legal assistance that they need. And far too many children and adults routinely enter our juvenile and criminal justice systems with little understanding of the rights to which they are entitled, the charges against them, or the potential sentences that they may face. In short, America's indigent defense systems exist in a state of crisis. Like many of you, this is something I have seen firsthand as a judge on the District of Columbia Superior Court and later as the United States Attorney for this city. I frequently witnessed the devastating consequences of inadequate representation. I saw that wrongful convictions and unjust sentences carry a moral cost that's impossible to measure and undermine the strength, the integrity, and the public trust in our legal system. I also recognize that in purely economic terms, they drain precious taxpayer resources and constitute an outrageous waste of court funds on new filings, retrials, and appeals just because the system failed to get it right the first time. Well, today, together, it's time to declare once again that this is unacceptable and unworthy of a legal system that stands as an example for all the world. It's time to reclaim Gideon's petition and resolve to confront the obstacles facing indigent defense providers everywhere. Most of all, it's time to speak out with one voice to rally our peers and partners at every level of government and the private sector to this important cause. Now, I'm proud to say that today's Justice Department is rising to this challenge, and we're responding to this call not with despair, but with dedication and with a plan for action. Alongside allies like the American Bar Association, which developed the landmark 10 Principles of a Public Defense Delivery System, my colleagues and I are fighting to institute the policies that we need to improve representation for the disadvantaged. And we're engaging with leaders like the National Association of Criminal Defense Lawyers, the National Legal Aid and Defender Association, state government officials, nonprofits, NGOs, and many others to drive this work into the future. Now, at the center of our efforts is the Department's Access to Justice Initiative, a new component that I launched in 2010 to help ensure that basic legal services are available, affordable, and accessible to everyone in this country, regardless of status, regardless of income. Under the past leadership of the incomparable Professor Larry Tribe and Mark Childress, and today thanks to the hard work of Acting Senior Counselor Deborah Leff and her staff, the Access to Justice Initiative is collaborating with a wide range of partners to broaden access to quality representation, to highlight best practices, and to bring new allies into this work. In addition, through the Office of Justice Programs and other components, the Department is developing concrete steps to help us better understand and to address indigent defense issues. Last year in New Orleans, I unveiled a grant program known as Answering Gideon's Call, through which the Bureau of Justice Assistance awarded $1.2 million in funding to 4 states, each of which has partnered with a research organization to track outcomes. Under another initiative funded by the National Institute of Justice and totaling $1.6 million, we're supporting research projects examining holistic defense approaches, studying factors that lead juveniles to waive their right to counsel, and evaluating the challenges of representing indigent defendants with mental health disorders. Beyond this, we are striving to bring stakeholders together, including law enforcement, court officials, prosecutors, indigent defense providers, and correctional officers to refine existing programs such as the Edward Byrne Memorial Justice Assistance Grants. We are developing a national-level census of public defender offices to provide a snapshot of the efforts that are underway across America, determine what works, and assess training and resource needs. For the first time ever, we're helping to offer free training sessions to jurists and other legal professionals who serve Indian country. We're working with the ABA to examine and to potentially mitigate the collateral consequences that often accompany certain convictions. And we're using the department's enforcement authorities in targeted ways to prompt defense system reform. Now, these and other initiatives are proof of this Justice Department's steadfast commitment to protecting the rights and the interests of the most vulnerable among us. There can be no question that this work shows tremendous progress, and we can all be proud of the efforts that so many of you are helping to lead. But there's also no denying that much remains to be done. Fortunately, all of this is only the beginning. And today I'm pleased to announce that the Justice Department will soon offer $1.8 million in new resources and tools to fulfill the rights guaranteed by Gideon, to provide assistance to the jurisdictions that need it most, and to bolster national efforts to build effective public defense systems across America. Through a second Answering Gideon's Call grant initiative focused on improving the effectiveness of right to counsel services, BJA will soon award over $700,000 to a nonprofit organization and its partners to support training and technical assistance based on the ABA's 10 principles. They will also reevaluate qualified applications for last year's grants under this program and will offer more than $250,000 each to 2 past applicants. In addition, the Office of Juvenile Justice and Delinquency Prevention will provide $400,000 to fund a project improving the level of systemic advocacy, the quality of representation for indigent juveniles, and the kinds of support available to the Juvenile Indigent Defense Bar. The National Training and Technical Assistance Center will commit a total of $90,000 for technical assistance to help several states meet their constitutional obligations to provide competent representation for the poor. And BJA will provide $50,000 to implement the Measures for Justice initiative in Milwaukee. It's a rigorous evaluation tool that will help illuminate strategies for success and empower criminal justice stakeholders to make the changes that they need. Now, of course, all of this assistance and support for cutting-edge research is dependent on funding that's made available by Congress. And in 2013, our funding is impacted by the sequester, which cut over $1.6 billion from the Justice Department's budget, including $100 million from essential grant programs like the ones that I've just announced. Put simply, this department cannot afford to lose such a significant portion of its budget, particularly in a time of uncommon challenges when many legal assistance organizations are facing shortfalls, and state and local officials have been asked to do more with less. And that's why it's imperative that congressional leaders quickly adopt a balanced deficit reduction plan to stop these untenable cuts. And it's also why today, more than ever before, prosecutors and defenders must come together to make the most of limited resources. As we look toward the future, we all must collaborate to improve our justice system. Since becoming Attorney General 4 years ago, I've urged my colleagues to step up and do just that. And I'm pleased that the dedicated men and women of the United States attorney community have taken this to heart. And many are working closely today with the defense bar in a variety of contexts. For instance, in Nebraska and in the Southern District of Iowa, our U.S. attorneys regularly meet with federal public defenders to discuss areas of mutual concern. In the Eastern District of Michigan, federal prosecutors are partnering with the Federal Defender's Office to hold public events and plan additional forums for discussion about pretrial services and other issues with the defense bar. Here in Washington, D.C., Justice Department leaders have worked with the federal public defenders and counsel appointed under the Criminal Justice Act to develop best practices for dealing with electronically stored information during the discovery process. And we've begun preliminary discussions about conducting a joint training session right here in the Great Hall so that prosecutors can learn alongside public defenders and CJA counsel from across the United States. In the end, this may be the single most important legacy of Gideon, that it serves as a reminder of the obligation entrusted to every legal professional, not merely to serve clients or to win cases, but to do justice. It stands as a testament to the fact that the structures and mechanisms of our legal system, far from being etched in stone, remain works in progress. And it's a powerful example of how, in this great country, even the humblest hands can help to bend the arc of history just a little further toward justice. Now, although Clarence Earl Gideon did not live to see even the 10th anniversary of this pivotal decision, his story and his indelible handwritten words remind us that we cannot rest in our efforts to see that justice is done. And we must never stop fighting to realize the principle that we have come to know by his name, by guaranteeing that every person in the country can access quality legal representation anytime they come before the criminal justice system. Colleagues, this is our solemn responsibility, and it is also our moral calling. And as I look over this crowd today and reflect on how far we've come in the last 50 years, despite the challenges of the hour and the obstacles ahead, I can't help but feel confident in where our indigent defense efforts will lead us over the next 50. So let us seize this moment and take advantage of this opportunity to act with optimism and without delay, to stay true to the values that have always guided our steps forward, and to stand up for the ideals that must always drive our ongoing pursuit of a more free, more just, and more perfect union. Thank you.